This video is for informational and educational purposes only and does not constitute legal advice. The path to becoming a lawyer is unique for every individual, and this presentation is intended to provide a general overview, not a guaranteed roadmap to success. Always consult with academic advisors, career services, and licensed professionals for guidance tailored to your specific situation. The courtroom is silent. 100 pairs of eyes are laser-focused on you. Your client, a man whose life is hanging by a thread, looks at you with a mixture of terror and hope. Across the aisle, the prosecutor smirks, confident. They've just spent 3 days laying out a mountain of evidence. Fingerprints, witnesses, a motive that seems unshakable. They've painted your client as a monster. The jury is convinced. The judge leans forward. And now it's your turn. You stand up, your heart pounding like a drum against your ribs. You take a deep breath and you begin to speak. This is the moment, right? This is the fantasy that sells a million TV shows. The dream that sends hundreds of thousands of students to law school every single year. The dramatic, last-minute objection. The stunning cross-examination that makes a witness break down on the stand. The closing argument so powerful it brings the jury to tears and snatches victory from the jaws of certain defeat. This is why you want to be a criminal lawyer. Well, I'm here to tell you that if that's your reason, you should probably stop right now. Because that Hollywood fantasy, that single glorious moment of courtroom combat, is maybe 1% of the job. The other 99% is a grueling, soul-crushing, paper-drenched marathon that most people are simply not built to survive. And the disconnect between that fantasy and the brutal reality is the #1 reason why so many bright, passionate people crash and burn, buried under 6 figures of student loan debt with a career they've grown to hate. So what is this really about? This isn't just another video listing the steps. Go to college, get a good GPA, take the LSAT, go to law school, pass the bar. You can find that information anywhere. No, this is your wake-up call. This is the conversation your guidance counselor is too afraid to have with you. We are going to rip back the curtain and expose the raw, unfiltered, and often ugly truth of what it actually takes day in and day out to become a successful criminal lawyer in the United States. We're going to cover the mindset you need to forge before you even think about applying to college. We'll dissect the personality traits that separate the legal legends from the cautionary tales. We'll talk about the ethical nightmares that will keep you up at night, and the immense psychological pressure that will test the very core of who you are. By the end of this journey, you won't just know the what and the how, you'll understand the why. And you'll be able to look yourself in the mirror and answer the only question that truly matters. Do you really have what it takes? Let's start by shattering the biggest myth of all, the myth of the righteous crusader. On TV, the defense attorney is always fighting for the wrongly accused, the innocent man framed by a corrupt system. And the prosecutor is always putting a clear-cut, mustache-twirling villain behind bars. It's clean. It's simple. It's morally satisfying. The reality? It's a swamp of moral ambiguity. Let's get one thing straight, and if you can't accept this, you are not cut out for this job. As a criminal defense attorney, you will be required to defend people you know are guilty. Not think are guilty. No, people who have done terrible, violent, and stomach-churning things. Your job is not to prove their innocence. Your job is to defend the United States Constitution. Your job is to ensure that the state, with all its immense power, proves its case beyond a reasonable doubt, following every single rule. You are the guardian of the process, not the arbiter of a single person's morality. Can you do that? Can you spend months, maybe years, of your life fighting tooth and nail for the freedom of someone whose alleged actions make your skin crawl? Can you sit across a table from the grieving family of a victim, knowing your job is to poke holes in their story, to challenge their memory, to make them look unreliable on the stand, all in the service of a client you believe is a monster? Because that is the job. And if you want to be a prosecutor, get ready for the other side of that coin. You think you'll just be putting away hardened criminals? You will also be prosecuting a desperate father who stole baby formula. You'll be prosecuting a teenager who made one stupid, life-altering mistake with drugs. You will hold the power to ruin lives, to take away someone's freedom, and you will have to make agonizing decisions about justice versus mercy every single day, often with incomplete information and immense public pressure. You will be forced to offer plea bargains to defendants you believe deserve much harsher sentences, simply because your office is overwhelmed and the evidence for a trial is weak. It's not about being a hero in a black and white world. It's about being a public servant swimming in a sea of gray. This isn't a job for the self-righteous. It's a job for the intellectually and emotionally resilient. It requires a profound, almost fanatical devotion to the system of law itself, above and beyond your personal feelings about any single case or client. If that sounds cold, that's because sometimes it has to be. Now let's talk about the second myth, the myth of the courtroom genius. We picture lawyers as silver-tongued orators, winning cases with a single brilliant turn of phrase. The truth is, trials are incredibly rare. The vast majority of criminal cases in the United States, upwards of 95%, end in a plea bargain. They never see the inside of a courtroom. So what does that mean for you? It means your most important skills aren't public speaking. They're reading, writing, and negotiation. The life of a real criminal lawyer is not spent in front of a jury. It's spent in a library, or more realistically, in a cubicle staring at a computer screen for 10 hours a day. It's sifting through thousands of pages of police reports, witness statements, forensic analyses, and legal precedent. A process called discovery. It's looking for one sentence, one inconsistency, one procedural error that you can leverage. It's writing motion after motion, motions to suppress evidence, motions to dismiss charges, that are dense, technical, and mind-numbingly boring to anyone but another lawyer. It's hours on the phone, haggling with the opposing counsel, not about guilt or innocence, but about years, months, and days of a potential sentence. Being a great criminal lawyer is less like being a master debater, and more like being a master watchmaker. It's about meticulous attention to detail, endless patience, and the ability to see how hundreds of tiny, intricate pieces fit together to form a whole. The eureka moment doesn't happen in a flash of inspiration in the middle of a trial. It happens at 2 in the morning on your third cup of coffee, when you finally find a contradiction between page 7 of Officer Smith's report and page 43 of the paramedic's log. It's a grind, a relentless, unforgiving, intellectual grind. Are you in love with that grind? Or are you just in love with the idea of the glory? Be honest with yourself. This job will expose the truth very, very quickly. And the first truth it exposes is whether you can live, breathe, and operate in a world that is almost entirely gray. See, most people think of the law as a set of rules. Black and white, right and wrong, guilty or innocent. That is a comforting, simple illusion. The reality of criminal defense is a permanent residence in the gray zone. It's a place where facts are slippery, motives are murky, and the truth is often a matter of perspective, buried under layers of fear, lies, and flawed memories. Can you handle that? I mean, really handle it? Let me paint you a picture. It's a Tuesday morning. You get a call from the public defender's office. You've been assigned a new client. His name is Leo. He's 19 years old. He's been charged with armed robbery and assault with a deadly weapon. The crime happened at a 24-hour convenience store 2 nights ago. The clerk, a 60-year-old man, was pistol-whipped and is now in the hospital with a fractured skull. The cash register was emptied. You go to the county jail to meet Leo for the first time. The room smells like stale bleach and despair. He's sitting on the other side of a thick plexiglass divider, wearing an orange jumpsuit that's 3 sizes too big. He looks terrified. He's just a kid. He tells you his story. He says he was just cutting through the alley behind the store on his way home. He heard shouting, got scared, and started running. Next thing he knows, a police car screeches to a halt, and he's thrown against the hood with a gun to his head. He swears on his mother's life he didn't do it. He's crying. Seems genuine. You want to believe him. Every fiber of your being that roots for the underdog, that despises injustice, wants Leo to be the innocent kid caught in the wrong place at the wrong time. Then you get the police report, the discovery file, and the gray starts to creep in. The witness, a woman who was getting gas across the street, described the robber as a young man in a dark hoodie. Leo was wearing a dark hoodie. The witness says the robber was about 6 feet tall. Leo is 6 feet tall. The police report states that when they apprehended Leo, he was fleeing the immediate vicinity of the crime. Why was he running? He told you he was scared. The police say it was consciousness of guilt. Who's right? You dig deeper. The security camera footage from the store is grainy, almost useless. The robber's face is obscured by the hoodie and a mask. You can't tell if it's Leo, but you can't tell if it's not Leo either. The gun was never found. The stolen cash was never found on him. That's good for your case. But then you look at Leo's record. It's not clean. A couple of priors for shoplifting when he was 17. Nothing violent, but it's not the pristine record of a choir boy either. It shows a pattern of poor choices. You go back to see Leo. You press him on the details. Leo, you told me you were coming from your friend Mark's house. But Mark's house is 6 blocks north. The convenience store was 3 blocks south of your route. Why were you down there? He hesitates. His eyes dart around the room. I took a shortcut. Through an alley? At midnight? Leo, it doesn't add up. He gets defensive. Angry. You're supposed to be on my side. You think I did it too, don't you? And in that moment, sitting across from this scared, angry young man, you have to make a choice. Not about whether you believe him. That's not your job. Your personal belief in his innocence is irrelevant. It is a luxury you cannot afford. Your job is to defend him. Your job is to look at the state's case, a shaky eyewitness, no gun, no money, a grainy video, and you have to dismantle it piece by piece. You have to hold the government to its sacred burden, to prove his guilt beyond a reasonable doubt. This is the reality. You will spend the majority of your career representing people who are in that gray zone. Some will be factually innocent, railroaded by a broken system. Some will be factually guilty, but the state's evidence will be weak or illegally obtained. And many you will simply never know for sure. You will have to fight for them all with the same ferocity. You have to be their champion, their shield, their only hope when the entire weight of the state is crashing down on them. People will ask you, how can you defend those people? They'll ask it at family dinners, at cocktail parties, in the grocery store. They'll look at you with a mixture of curiosity and disgust. They see you as an accessory, a loophole finder, an enabler of criminals. They won't see the nuance. They won't see the presumption of innocence. They won't understand that you're not defending the crime. You're defending the Constitution. So how do you sleep at night? You sleep at night because you understand something most people don't. The criminal justice system is not a machine for determining absolute truth. It's a system designed to prevent government overreach. Your role as a defense attorney is to be the emergency brake on that system. You are the guardian at the gate. You force the police to follow the rules. You force the prosecution to prove their case. You ensure that the awesome power of the state to take away a person's liberty is checked at every single turn. Because when an innocent person is convicted, a terrible injustice occurs. But it's not just one injustice. There are two. The first is to the original victim of the crime, who never gets justice because the real perpetrator is still free. The second is to the innocent person who is locked in a cage, whose life, family, and future are stolen from them. You are the last line of defense against the creation of that second victim. That's how you sleep at night. You sleep at night by compartmentalizing. You develop a form of professional detachment that allows you to analyze a case with cold, hard logic, while still maintaining the human empathy required to build trust with your client. It's a difficult, draining tightrope to walk. You have to care deeply about your client's fate, but you can't let their potential guilt paralyze you or compromise your advocacy. So I ask you again, look inside yourself. Could you sit across from Leo with that pit of doubt in your stomach and still look him in the eye and say, I've got your back. We're going to fight this? Could you stand up in a courtroom in front of a jury and a judge and the victim's family and argue with absolute conviction that the state has not met its burden? Could you handle the whispers, the judgment, the social cost of standing up for the accused, the unpopular, the person society has already decided is a monster? Because if you can't stomach the gray, if you can't find your footing in that moral ambiguity, then all the brilliant legal arguments in the world won't matter. You'll burn out, or worse, you'll break. But if you can, if that challenge excites you, if the idea of being the lone shield against the sword of the state sets a fire in your soul, then we need to talk about the most underrated weapon in a criminal lawyer's arsenal. And it's not what you see on TV. It's the ability to sit across a small metal table in a cold concrete room, look at a person whose society has already labeled a monster, a thug, a lost cause, and find the human being inside. It's the power to listen past the confession, to look beyond the police report, and to hear the story that no one else has bothered to ask for. This isn't about bleeding heart sympathy. This is a tactical, intellectual, and emotional discipline. It's the practice of what I call aggressive understanding, because in criminal defense, understanding isn't a weakness. It's the sharpest edge of your sword. Let me paint you a picture. A file lands on your desk. It's an armed robbery case. Your client is a 19-year-old kid. The evidence is overwhelming. He was arrested 2 blocks from the convenience store, sweating, out of breath. He had the cash from the register in his pocket, still in the bank-branded wrapper. He had the gun, a small black pistol, tucked into his waistband. And to top it all off, he gave a full videotaped confession at the station. He said, I did it. I robbed the store. The prosecutor calls you. He's feeling generous. Look, he says, this is an open and shut case. Your kid is looking at 10 years minimum with a firearm enhancement. But I'll tell you what. He's young. He pleads guilty tomorrow, we'll recommend 7 years. It's the best deal he's ever going to see. The TV lawyer, the one you see in movies, would slam down the phone. He'd start looking for a loophole. Was the search illegal? Was the confession coerced? He's looking for a technicality, a magic bullet to make the whole thing go away. And sometimes that's the right move. But the truly great criminal lawyer knows that 99% of the time, the magic isn't in the law books. It's in the client. So you don't look for a loophole first. You go to the jail. You sit down with this 19-year-old kid. He won't make eye contact. He's terrified. He just mumbles, I did it. I should just plead guilty. Take the 7 years. This is the moment. This is the test. Do you see a case file, a number, a slam dunk for the prosecution? Or do you see a human being at the lowest point of his life? You don't ask him, what happened? He already told the cops what happened. You start asking the questions no one else did. Tell me about your family. Where did you grow up? What was school like for you? Who's your best friend? What were you afraid of when you were 10 years old? What are you afraid of now? He's hesitant at first. Why does this lawyer care about his childhood dog, or the fact he was bullied in middle school? But you persist. You don't judge. You just listen. And slowly, painstakingly, the real story begins to emerge. You learn that he doesn't have a father in the picture. His mom works 2 jobs, cleaning offices at night just to keep the lights on. You learn he has a little sister, she's 8 years old, and she's his whole world. You learn that 3 weeks ago, she was diagnosed with a rare form of leukemia. The doctors said she needed a specialized treatment, a treatment the family's insurance called experimental, and refused to cover. The out-of-pocket cost was astronomical. They were going to lose their apartment just to afford the first round of medication. You learn that this 19-year-old kid, who was working at a car wash, felt the entire weight of his family's world crushing him. He saw his mother crying silently at the kitchen table every night. He saw his little sister getting weaker. He felt helpless, desperate. And then you ask about the gun, the small black pistol from the police report. He finally looks at you and his eyes are filled with tears. It was a toy, he says. It's a BB gun. I bought it at Walmart 2 years ago. It doesn't even work anymore. Suddenly, the armed robbery with a firearm enhancement looks very, very different. Still a robbery. He still committed a serious crime. But the narrative has been shattered. This isn't a cold-blooded, violent predator. This is a terrified, misguided boy who made the worst decision of his life out of a desperate, twisted sense of love and responsibility. He confessed because he believed he was a monster. He believed he deserved to be punished. He was ready to throw his life away. Now what do you do with this? This is where the second most underrated weapon comes into play, your ability to write. Forget the thundering courtroom speeches for a moment. The most important battles in criminal law are often won not with your voice, but with your keyboard. They are won in the silent, lonely hours of the night as you craft a document that will land on the prosecutor's desk and later, the judge's. You don't just file a motion to dismiss. You write what's called a sentencing memorandum or a deviation request. But you don't fill it with dry legal citations. You tell a story. You use that aggressive understanding you fought so hard to gain. You start with the 8-year-old sister. You attach her picture. You include the doctor's reports, the insurance denial letters. You describe the quiet desperation in that household. You paint a vivid picture of a 19-year-old kid who wasn't trying to buy new sneakers or a video game, but was trying to save his sister's life. You humanize him. You take him from a statistic, another armed robber, and you turn him back into a person. A son. A brother. You explain the weapon was an inoperable BB gun. Attaching the receipt from Walmart. You argue that the firearm enhancement, which carries years of mandatory prison time, doesn't legally or morally apply. You send this document, this story to the prosecutor, the same prosecutor who offered you 7 years. And you wait. Few days later he calls you back. His tone is different. He's no longer smug. He's read your document. He's seen the pictures. He's seen the medical bills. He's a human being too. Look, he says, the BB gun thing changes things. The statute is specific. And the story with his sister, it's tragic. Let's talk about a different resolution. Maybe a felony theft charge. No jail time. Probation. mandatory counseling, and community service. And just like that, you have saved this kid's life. Not with a clever loophole, not with a dramatic courtroom trick, but by listening, by understanding, and by telling a compelling, truthful story on paper. You changed the entire gravity of the case before a jury was ever picked. This is the real work. It is emotionally draining. You will carry the weight of these stories with you. You will lie awake at night thinking about your clients' families, their fears, their trauma. You will absorb their pain, and you must be strong enough to turn it into a tool for their defense. It requires a level of emotional resilience that is almost superhuman. You have to be able to dive into the darkest parts of the human experience and not drown. You have to be a counselor, a strategist, a writer, and a warrior all at once. This is the foundation. This ability to see the human behind the accusation. But building a legal career on this foundation requires a formal, brutal, and often counterintuitive education. You have to get into law school, and then you have to survive it. And law school is a place that can, if you're not careful, beat that very empathy right out of you. It's a trial by fire designed to reshape the way you think, speak, and see the world. Before you can even face that, you have to conquer the first great dragon guarding the gates of the legal world. A bizarre and punishing exam known as the LSAT. The law school admission test. It doesn't sound that intimidating, does it? LSAT, for simple letters. But for aspiring lawyers, those 4 letters spell out a unique and profound form of intellectual torment. This isn't like the SATs or any other standardized test you've ever taken. The LSAT doesn't care what you know. It doesn't care about your grasp of history, your knowledge of science, or your ability to recall a single fact. It is designed with a singular, ruthless purpose: to measure your ability to think like a lawyer before you've ever even opened a law book. It's a test of pure, raw, analytical processing power. Imagine you're handed a series of short arguments, the kind you hear every day in advertisements, political speeches, or debates with friends. But instead of just agreeing or disagreeing, you have to dissect them. You have to identify the core assumption, find the hidden flaw, and articulate precisely why the conclusion doesn't hold up. For example, a passage might say, "Every time our city's ice cream sales go up, the crime rate also goes up. Therefore, to reduce crime, we should limit ice cream sales." Your job, in under 90 seconds, is to recognize that this confuses correlation with causation. The ice cream isn't causing the crime. The hot weather is likely causing both. That's a simple one. Now imagine dozens of these, each more complex, more nuanced, and filled with deliberately confusing language, and you have the first section, logical reasoning. It trains your brain to stop taking information at face value and to start probing for the weak points in every single statement you encounter. But that's just the warm-up. Then comes the section that has broken the will of countless aspiring attorneys: analytical reasoning, better known to its victims as the logic games. This is where the LSAT transcends a normal exam and enters the realm of a bizarre, surreal mind-bender. A logic game will present you with a set of rules, a scenario that exists nowhere in the real world. Something like, a film festival is scheduling 7 movies, 4 dramas and 3 comedies. The movies are shown one at a time. A comedy cannot be shown immediately after another comedy. The second movie shown must be a drama. The movie Justice must be shown sometime after the movie Betrayal, but before the movie Redemption. And from that web of constraints, you have to deduce with absolute certainty what must be true, what could be true, and what cannot possibly be true. It's a pure test of your ability to hold a complex system of rules in your head, manipulate variables, and make valid inferences under crushing time pressure. You have about 8.5 minutes per game. It feels like trying to solve a Sudoku puzzle while a bomb is ticking, and the puzzle keeps changing its own rules. There is no partial credit. There is only right or wrong. Finally, there's reading comprehension. Again, this is nothing like reading for pleasure. You'll be given 4 incredibly dense, academic passages on topics you've likely never encountered. One might be about the differing theories on the migratory patterns of the Arctic tern. The next might be a comparative analysis of 2 competing schools of 17th century legal philosophy. Your task is not to understand and appreciate the text. Your task is to perform a surgical strike. You have to extract the author's main point, identify the primary purpose of a specific paragraph, and infer what the author might think about a topic they never even mentioned. It's about reading not for content, but for structure, tone, and logical flow. It's like being a detective at the scene of a crime, but the crime scene is a wall of text, and the clues are hidden in the author's choice of adverbs. So why this strange, punishing ritual? Why does this one test hold so much power? Because law schools believe it is the single best predictor of your ability to survive the first year of law school. The relentless logic, the need to make deductions from a fixed set of rules, the skill of deconstructing dense text. These aren't just abstract test-taking skills. They are a direct simulation of what you will be doing day in and day out as a law student. Reading a complex judicial opinion is like LSAT reading comprehension on steroids. Applying a statute to a set of facts is a real-life logic game. Arguing in front of a professor is a high-stakes logical reasoning section. The LSAT is the boot camp for your brain. And the result of this boot camp is a single brutal number. The score is on a scale from 120 to 180. The average score is around 152. To get into a good law school, you need to be pushing 165. To get into one of the elite top-tier schools, a Harvard, a Yale, a Stanford, you are looking at a 173 or higher. The difference between a 165 and a 173 might only be about 10 questions on the entire exam. But the impact is monumental. It's the difference between a regional school with a small scholarship and a top 10 school with a full ride. It's the difference between doors swinging wide open and doors being slammed shut before you even get a chance to knock. That one number becomes your brand, your scarlet letter, or your golden ticket. It's a cold statistical filter that admissions committees use to sort through tens of thousands of applications. The preparation for this test is a journey into obsession. Consumes your life for months, sometimes even a year. You buy stacks of books with names like the LSAT Trainer and the Logic Games Bible. You might spend thousands of dollars on a prep course. Your social life evaporates. While your friends are going out, you're at home drilling yourself on conditional reasoning. You start talking in LSAT terms. You'll hear a friend say, "If I get a raise, I'll buy a new car." And your brain will automatically diagram it. ROC. Then you'll think, what's the contrapositive? If I don't buy a new car, it means I didn't get a raise. You start to see logical flaws everywhere. In commercials, in news reports, in your parents' arguments. The test literally rewires your brain. It's also a profound psychological battle. You will take a practice test one week and feel like a certified genius, hitting your target score. The next week, you'll take another under identical conditions, and your score will plummet by 7 points for no discernible reason. You will feel like an absolute idiot. You will question if you're smart enough, if you have what it takes. The test is designed to do this. The answer choices are masterfully crafted traps. There is always the correct answer, and then there is an answer that is almost correct, one that preys on a common misunderstanding or a slight misreading. Choosing between them over and over for hours is mentally exhausting. Then comes the day. You walk into a silent, cavernous lecture hall or a sterile testing center. The air is thick with anxiety. You sit down at a small desk with your number 2 pencils, your analog watch, and nothing else. The proctor reads the instructions in a flat, emotionless voice. The clock starts, and the world outside ceases to exist. It's just you and the test booklet. You tear through the first section, your confidence building. Then you hit the second section, and it's a logic game from your worst nightmares. The rules seem to contradict each other. The setup is unlike any you've ever practiced. Panic begins to creep into the edges of your mind. You can feel your heart beating in your throat. You look at the clock. 6 minutes have gone by, and you haven't answered a single question. This is the moment of truth. Do you stick with it, risking running out of time for the whole section? Or do you cut your losses, guess on all 5 questions, and move on, hoping to make up the points elsewhere? Every single person who has taken the LSAT has faced a moment just like this. After it's over, after 3.5 hours of the most intense mental exertion of your life, you walk out into the sunlight in a daze. And then comes the worst part of all, the wait. For 3 long weeks, you live in a state of suspended animation. You replay the test in your head, agonizing over questions you might have missed. Your entire future, all those months of sacrifice, all your dreams of becoming a lawyer, feel like they're locked in a digital vault at the Law School Admission Council, waiting to be judged. Finally, the email comes. Your LSAT score is now available. Your hands shake as you type in your password. You close your eyes, take a deep breath, and click. And there it is. A 3-digit number that will, in a very real way, dictate the next 3 years of your life and the first decade of your career. This single test is a crucible. It has almost nothing to do with justice or fairness, or the passion that drives someone to defend the accused. It's a cold, analytical gauntlet, but it is the dragon that guards the gate. And if you conquer it, if you score that magic number, you have finally earned the right to face the real challenge. surviving law school itself. Law school is not a continuation of college. It's an intellectual ambush. Forget everything you think you know about learning. Forget collaboration. Forget gentle encouragement. The first year, what they call the 1L year, is a carefully engineered psychological crucible designed to do one thing: break you down and rebuild you in the image of a lawyer. You walk in on the first day bright-eyed, clutching a stack of casebooks that cost more than a used car, and you sit down in a massive lecture hall that feels more like an ancient amphitheater. There's a nervous energy in the air, a hum of overachievers all sizing each other up, and then the professor walks in. They don't say hello. They don't introduce the syllabus. They open a book to a random page, look out over the sea of 200 terrified faces, and call a name. This is the Socratic method, and it is brutal. It's not a lecture, it's an interrogation. The professor will pick you, and for the next 10, 20, sometimes 40 minutes, you are the only person in that room who matters. They will grill you on a 17th century property law case you were supposed to read the night before. But they don't want to know the facts. They want to know your reasoning. They'll ask you a question. You'll give an answer. They'll ask why. You'll explain. They'll poke a hole in your logic. You'll try to patch it. They'll tear the patch away and expose a deeper flaw. They will twist your words, present you with impossible hypotheticals, and force you to defend a position you don't even agree with. The entire time, hundreds of your peers are watching, silently praying it isn't them, and taking notes on your slow intellectual dissection. The goal isn't to humiliate you, though it often feels that way. The goal is to strip away your lazy, assumption-based thinking. It teaches you to never make a statement you can't defend from every conceivable angle. It's a baptism by fire, and you either learn to think on your feet, to be precise, to be fearless, or you drown. And while this public trial is happening, you are simultaneously being buried alive in reading. They call it drinking from a fire hose, but that doesn't do it justice. It's more like trying to catch a waterfall in a teacup. For every hour you spend in class, you're expected to spend 3 to 4 hours preparing. That means reading dense, archaic legal opinions written by judges hundreds of years ago. You're not just reading for plot. You're briefing every case. You're hunting for the specific legal rule, the holding, the rationale, and the dissenting opinions. You'll be reading about contracts, where the placement of a single comma can mean the difference between $1 million deal and a worthless piece of paper. You'll study torts, the law of civil wrongs, and suddenly see potential lawsuits everywhere. That shaky railing, that wet floor, that gossip whispered in the hallway. You'll wrestle with civil procedure, a labyrinth of rules so complex and arcane it feels like learning a dead language, but it's the language that governs every single lawsuit in the country. And then there's criminal law. This is where it gets real. This is where you first encounter the concepts that will define your career. You'll read cases that turn your stomach, cases of unbelievable cruelty and heartbreaking tragedy. And your job is not to feel. Your job is to analyze, to clinically break down a horrific event into its component parts. Actus reus, the guilty act, and mens rea, the guilty mind. Did the defendant intend to cause the harm? Did they act with malice? With negligence? With reckless disregard for human life? You learn that the same act, taking a life, can be first-degree murder, second-degree murder, voluntary manslaughter, or involuntary manslaughter, all depending on the precise state of mind of the person in that exact moment. You're forced to argue for outcomes that feel morally wrong, to defend the indefensible, not because you believe it, but because the law demands that every element be proven beyond a reasonable doubt. You're not learning facts. You're learning a new morality, a legal morality, where logic is king and emotion is a liability. All of this happens under the shadow of the curve. In law school, you're not graded on what you know. You're graded on what you know compared to the person sitting next to you. The school predetermines that only a certain percentage of students can get an A, a certain percentage will get a B, and so on. Your grade is entirely dependent on your rank in the class. The brilliant, hard-working student who would have gotten a 4.0 in college might be a B- student here, simply because everyone else is just as brilliant and hardworking. This creates an atmosphere of intense, sometimes toxic, competition. Outlines, the condensed study guides that are the key to survival, are guarded like state secrets. Study groups can feel more like intelligence-gathering operations than collaborations. The pressure is immense because your 1L grades are everything. They determine whether you get on Law Review, the prestigious student-run journal. They determine whether you get a coveted spot in a moot court competition. And most importantly, they determine your chances of landing a good summer job, the first real step into the legal world. But something happens amidst the terror and the pressure. You start to change. You start to think differently. You're watching the news and you're no longer just hearing a political argument. You're spotting the logical fallacies, the unsupported conclusions. You're about to sign a new apartment lease and you actually read the fine print, understanding the obligations and liabilities you're taking on. Your brain is being rewired. You learn to listen more than you speak. You learn to choose your words with surgical precision. You develop an allergy to ambiguity. This is what they mean by learning to think like a lawyer. It's the ability to look at any situation, any story, any problem, and immediately identify the core issues, anticipate the counterarguments, and see the hidden structure of rules and relationships beneath the surface. After the shared trauma of the first year, the path begins to fork. You get to choose your electives. While some of your classmates are diving into corporate tax law or intellectual property, you find yourself drawn back to the raw human drama of criminal law. You sign up for criminal procedure, learning the intricate dance between law enforcement and individual rights defined by the 4th, 5th, and 6th Amendments. You take evidence, mastering the 1001 rules that govern what a jury is and is not allowed to hear. And you take trial advocacy. This is where you finally get on your feet. In a mock courtroom, you practice delivering opening statements, cross-examining witnesses, and making closing arguments. You learn how to command a room, how to tell a story, how to persuade. But the most profound shift happens when you step out of the classroom and into a legal clinic. Many law schools run criminal defense or prosecution clinics where, under the supervision of a professor, you get to work on real cases with real clients. And that first client meeting will change you forever. You're no longer reading about a defendant in a century-old casebook. You're sitting in a small sterile room across from a living, breathing person. A person who is scared, who is confused, and whose entire future might rest in your hands. Suddenly, the abstract legal doctrines have a face. The concept of reasonable doubt is no longer an academic puzzle. It's the fragile thread a person's liberty hangs from. You feel the crushing weight of responsibility. A missed deadline, a poorly phrased question, a failure to object. Your mistakes don't just lower your grade anymore. They could mean the difference between a person going home to their family or going to prison. This is the moment the training wheels come off. This is the moment you stop being just a student of the law, and you start to become a guardian of it. The question is no longer can you survive law school, but can you survive the stakes of the real world? And those stakes are immediate and they are monumental. Because before you can even step foot in a courtroom as a licensed attorney, you have to face the beast. The gatekeeper. The great filter of the legal profession. I'm talking about the bar exam. Imagine spending 3 years of your life, and hundreds of thousands of dollars, to learn a new language, the language of the law. Now imagine you have to prove your fluency in a single 2-day test that covers everything you've ever learned, and a whole lot you haven't. That is the bar exam. It's not a test of intelligence. It's a test of endurance. A psychological gauntlet designed to break you. The summer after you graduate from law school isn't a celebration. It's a self-imposed prison sentence. You spend 10 to 12 hours a day, 6 or 7 days a week, locked in a room with stacks of books that could anchor a battleship. You're trying to cram the entirety of American jurisprudence into your skull. Torts, contracts, property law, evidence, criminal procedure, constitutional law. Dozens of subjects, each with thousands of nuanced rules and exceptions. Your friends with normal jobs are going on vacation. They're getting married. They're living their lives. You are mainlining caffeine and highlighting textbooks until your vision blurs. The self-doubt is a constant, suffocating presence. You'll be staring at a practice question about the rule against perpetuities, a notoriously convoluted property law concept, and you'll have a full-blown existential crisis. What am I doing? I don't know any of this. I'm going to fail. I just wasted 3 years of my life. Every single person who takes that test feels that way. It's part of the process. Then comes the exam itself. 2 days of pure, unadulterated mental combat. The first day is often the multi-state bar examination, or MBE. 200 multiple-choice questions. But these aren't your high school scantrons. Every question is a complex fact pattern, a miniature story, and each answer choice is designed to be deceptively plausible. They are engineered to exploit your fatigue and your second-guessing. It's a 6-hour sprint through a minefield of legal minutiae. The second day is the essay portion. This is where they test your ability to think like a lawyer under fire. You're given a story, a car crash, a botched business deal, a criminal accusation, and you have a very short amount of time to spot every single legal issue, recite the relevant black-letter law from memory, apply that law to the specific facts, and arrive at a coherent conclusion. You do this over and over again for hours until your hand is a cramped claw and your brain feels like hot static. And then it's over. You walk out of the testing center into the sunlight, a hollowed-out shell of a human being. And you wait. You wait for months. An agonizing, soul-crushing period where your entire future, your identity, everything you've worked for, hangs in the balance of a single pass/fail score. When that list of names is finally published, it's a moment of either pure, unadulterated ecstasy or the most profound devastation you've ever felt. But let's say you pass. You did it. You are officially an attorney. You take the oath. You are a member of the bar. Now the real terror begins, because now you have to actually be a lawyer. And for a brand new criminal attorney, this is where you face your first great philosophical and professional crossroads. Do you become a prosecutor, or do you become a defense attorney? On one side, you have the district attorney's office. You become an assistant district attorney, or ADA. You represent the people. You work with the police. Your job is to hold criminals accountable, to seek justice for victims, and to protect the community. There's a powerful allure to this path. A steady government paycheck, benefits, and a clear sense of purpose. You're wearing the white hat. You're one of the good guys. The reality, however, is a swift and brutal education. As a junior ADA, you're not getting the high-profile murder trial you saw on TV. You're thrown into misdemeanor court, what they call the misdemeanor mill, or the docket of despair. You're handed a stack of files an inch thick, and that's your caseload for the day. DUIs, shoplifting, bar fights, domestic disputes. It's a relentless fire hose of human fallibility. You quickly learn that your job isn't always about a noble search for truth. It's about managing an overwhelming caseload. It's about efficiency. It's about moving the cases. The pressure is immense. Your boss wants convictions. The police want you to be tough. The victims want retribution. And you're standing there 6 months out of law school, trying to decide if the evidence is strong enough to ruin someone's life over a $75 theft. You'll look at the defendant, who might be a single mother who stole diapers, or a kid with an addiction problem, and that black and white good versus evil narrative you walked in with begins to dissolve into an uncomfortable, confusing shade of gray. You start to see the machinery of the justice system from the inside, and you realize how easy it is for a person to get caught in its gears. On the other side of the aisle is the defense. Here too the path splits. You can join the public defender's office, or you can hang your own shingle and go into private defense. The public defender's office is the emergency room of the legal world. You represent the indigent, the people who cannot afford a lawyer. The Constitution guarantees them a defense, and you are that guarantee. This is arguably the purest, most challenging form of criminal law. You are the last line of defense between an individual and the immense, overwhelming power of the state. If you thought the ADA's caseload was bad, the public defender's is catastrophic. You might be juggling hundreds of felony cases at once. You have no resources. The DA has an entire police department and a state-funded crime lab to build their case. You have a part-time investigator if you're lucky. You spend your days running between courtrooms, your nights visiting clients in jail, trying to piece together defenses with spit and baling wire. You will be overworked, underpaid, and emotionally drained. You will see the absolute worst of the system, the biases, the shortcuts, the injustices. You will lose. A lot. But the wins? A win for a public defender is monumental. Securing a not guilty verdict for an innocent client, getting a fair plea deal that gives a deserving person a second chance. Those victories are the fuel that keeps you fighting in a seemingly hopeless war. Then there's private criminal defense. This is a different kind of pressure. You're not just a lawyer anymore. You're an entrepreneur. You have to find your own clients. You have to network, advertise, and build a reputation. Your clients are people who have scraped together every penny they have because their life, their career, and their family are on the line. The pressure to win isn't coming from a government bureaucracy. It's coming from the terrified human being sitting across the desk from you, whose freedom is literally in your hands. A loss doesn't just mean a bad statistic. It means you failed the person who put their absolute trust in you. Whichever path you choose, that first year is a trial by fire. The imposter syndrome is crippling. You stand up in court, your heart pounding in your chest, and you recite the words, "Your Honor," your name, appearing on behalf of the defendant, and you're convinced everyone in the room knows you have no idea what you're doing. You'll be negotiating a plea deal with an opposing counsel who has been doing this since before you were born, and they can smell your inexperience from a mile away. You learn that the skills that got you through law school are almost useless here. Your ability to cite case law is secondary to your ability to calm down a hysterical client, to read a jury's body language, or to persuade a hardened prosecutor to see the human being behind the police report. You are no longer a student of abstract legal theory. You are a crisis manager, a grief counselor, a strategist, and a storyteller, all rolled into one. You've passed the test, you've picked your side. But the real education, the one that will define your entire career, has only just begun. You have to learn how to actually fight. How do you stand in front of 12 strangers and convince them of your version of reality? How do you take the government's seemingly airtight case and dismantle it, piece by agonizing piece, under the watchful eye of a judge? This is where you stop being a lawyer, and you start becoming a trial attorney. And the trial is your theater. It's your battlefield. It is a crucible where facts are forged, lies are exposed, and futures are decided. Forget what you've seen on television. A real trial isn't a series of surprise witnesses and dramatic confessions. It's a grueling psychological war of attrition, fought with words, strategy, and an encyclopedic knowledge of the law. And it begins long before the first witness is ever called. It begins with something called voir dire. That's a fancy French term for jury selection. But what it really means is to speak the truth. This is your first and arguably most important battle. You are not trying to pick a jury that will love your client. You are trying to get rid of the jurors who are already predisposed to hate him. You are a human lie detector, a psychologist, and a strategist all at once. You have a limited number of strikes, chances to remove a potential juror without giving a reason. You have to make each one count. Imagine your client is a tech CEO accused of fraud. You look out at the jury pool. You see a retired union worker who has spent his life fighting against corporations. You see a young artist who believes all profit is theft. You see a teacher whose pension was wiped out by a Wall Street scandal. These people might be the kindest, most honest souls on the planet, but they are walking into that courtroom with a lifetime of biases that are a landmine for your case. Your job is to find them. But you can't just ask, "Excuse me, juror number 7, do you hate rich people?" They'll say no. Of course they'll say no. So you dance. You ask questions that reveal their worldview without them even realizing it. Ms. Smith, what are some news sources you trust? Mr. Jones, can you think of a time a large company did something you felt was truly positive for the community? You're not listening to their answers as much as you're watching how they answer. The hesitation, the flicker of contempt in their eyes, the arms that cross defensively over their chest. You're looking for the subtle tells that betray the biases they won't admit, even to themselves. This isn't about finding 12 people who will be your friends. It's about finding 12 people who are capable of setting aside their preconceived notions and listening to the evidence. It is a delicate, exhausting, and absolutely critical art form. Once you have your jury, the curtain rises. It's time for your opening statement. This is not an argument. You are legally forbidden from making arguments at this stage. This is a story. It is the trailer for the movie the jury is about to watch. And you are the narrator. The prosecution will go first, and they will paint a picture of evil. They will lay out a simple, damning narrative. The defendant did this, and we will prove it. Their story will be straightforward and easy to follow. Your job is to provide a counter-narrative, a different lens through which the jury can view every single piece of evidence that follows. You must plant the seeds of reasonable doubt before the first piece of evidence is even presented. A weak opening is, the evidence will show that my client is not guilty. It's boring. It's defensive. A strong opening grabs them. Ladies and gentlemen, this is a case about a single photograph. A grainy, out-of-focus picture taken from 100 yards away. And the government is going to ask you to ruin a man's life based on it. But we're going to look closer at that photograph. We're going to zoom in. And we're going to show you not what the government wants you to see, but what is actually there. You see the difference? You've given them a theme. You've given them a job to scrutinize, to look closer. You've framed the entire case around a central, understandable conflict. You are telling a story of mistake, of misinterpretation, of a rush to judgment. Your story must be more compelling, more human, and more believable than the government's. Because the first story a jury hears is often the one they stick with. Then comes the meat of the trial, presenting evidence and witnesses. When it's your turn, this is called direct examination. This is where you build your case, brick by painstaking brick, through your own witnesses. The goal here is clarity and control. You want your witness to be the star. You are merely the guide asking simple open-ended questions. Who? What? When? Where? Why? How? Mr. Davis, where were you on the night of October 5th? Who were you with? What did you observe? Each question is a building block in the wall of your narrative. You want the story to flow logically and chronologically from your witness's mouth to the jury's ears. It should feel natural, conversational, and above all, truthful. You already know every answer because you have spent dozens, maybe hundreds of hours preparing this witness. There are no surprises here. This is the careful, methodical construction of your version of reality. And then there's cross-examination. This is the part everyone waits for. This is the duel. This is where you get to dismantle the prosecution's case. But again, it is nothing like the movies. You will almost never ask a question you don't already know the answer to. A trial lawyer asking what happened next to an opposing witness is a lawyer committing malpractice. That's an invitation for the witness to repeat their entire damaging story to the jury. Cross-examination is not about discovery. It's about control. It is a surgical procedure performed with leading questions. A leading question is one that suggests the answer, often requiring a simple yes or no. You are not asking the witness to tell a story. You are telling the story to the witness and forcing them to agree with you one small, undeniable fact at a time. Let's say a police officer is testifying for the prosecution. He claims he saw your client throw something from his car during a chase. On direct, he'll sound confident, heroic. On cross, you take that confidence apart. You don't ask, "Are you sure you saw him throw it?" He'll just say yes. Instead, you control him. "Officer, you were driving at over 80 miles per hour, correct?" "Yes." "And the defendant's car was also moving at a high rate of speed?" "Yes." "It was dark out?" "Yes." "Your headlights were on?" "Of course." "And the defendant's taillights were on?" "Yes." "So there was glare from both sets of lights?" "I suppose." "You were focused on the road, on not crashing your vehicle?" "My primary focus was on pursuit, yes." "A pursuit which is a dangerous and stressful situation?" "It can be." "And you were radioing for backup at the same time?" "Yes." "And you were operating your siren and emergency lights?" "Yes." "And it was during all of this, driving at 80 miles per hour at night with glare in a stressful situation while operating a radio and lights, that you claim to have seen a small object, for a split second, fly out of the passenger side window of the car in front of you?" You stop there. You don't ask the ultimate question. You don't say, "So how could you possibly be sure?" You let the 12 people in the jury box ask that question in their own minds. You have led them to the water. It's their job to drink. You have taken the government's star witness and used his own testimony to show the jury how impossible, how unreliable, his story truly is. That is the art of cross-examination. It's a death by 1,000 cuts. Finally, after all the evidence has been presented, all the witnesses have been questioned and cross-examined, it's time for the closing argument. The opening was a promise. The closing is the proof. Now you are allowed to argue. Now you can draw conclusions. You weave together all the threads, the testimony, the exhibits, the holes you poked in the prosecution's case, into one final, cohesive, and powerful narrative. You remind the jury of the story you told them in your opening statement. Remember that grainy photograph? Let's talk about it. You walk them through the evidence, not as a dry list, but as chapters in your story. You contrast the prosecution's theory with the reality you've presented. You speak directly to their reason, but also to their sense of fairness, their sense of justice. This is your last chance to speak to them. You look them in the eye. You empower them. You remind them that the government's burden of proof, beyond a reasonable doubt, is the highest standard in our legal system. It is a shield designed to protect the innocent, even if it means a guilty person sometimes goes free. You remind them that a probably or a maybe is not enough to convict, not enough to take away a person's liberty. Your voice, your passion, your logic, your belief in your client's case. It all comes down to this final performance. Everything you've worked for months or even years culminates in these last few moments. The jury is about to be led out of the courtroom and into a small room, where they will hold a person's entire future in their hands. And your words will be the last thing they hear. And then silence. The heavy oak door clicks shut behind the last juror, and the sound echoes in a courtroom that suddenly feels vast and empty. The energy, the tension, the focus of the last several days or weeks has just been vacuumed out of the room, leaving a hollow stillness in its place. All your preparation, your strategy, your performance, it's done. You've fired your last shot. Now you're powerless. It's an unnerving, deeply unsettling feeling. You are a professional problem solver whose problem is now locked in a room where you are not allowed to go. You turn to your client. Their face is a mask of terror, hope, and exhaustion. They look at you, their eyes pleading for an answer you don't have. "What do you think?" they whisper. It's the question every client asks, and it's the one you can never truly answer. So you do what you have to do. You become the anchor. You talk them through it. You might say, "We did everything we could. We put on the best case possible. Now we have to trust them to do the right thing." You don't make promises. You never promise a win. That's malpractice, and more importantly, it's a lie. The jury is a black box. A dozen different life experiences, biases, and interpretations, all churning together to produce a single binary outcome. The waiting is its own special kind of torture. Could be 45 minutes. Could be 3 days. Every minute that ticks by feels like an hour. You and your client might sit in the near-empty courtroom, making small talk about the weather, their kids, anything to keep their mind off the reality of what's happening just a few yards away. Or you might go to the courthouse cafeteria, nursing a lukewarm coffee that tastes like dread. You keep your phone glued to your hand, your ringer on loud, waiting for the call from the clerk. Every time it buzzes with a spam call or a text from your spouse asking what's for dinner, your heart leaps into your throat. You find yourself replaying the trial in your head, an endless loop of what-ifs. Did I phrase that question to the star witness correctly? Should I have objected to that one comment the prosecutor made in closing? Did that one juror who kept nodding off actually hear my key point about reasonable doubt? It's a form of self-flagellation, but it's impossible to stop. You are a finely tuned analytical machine, and now your machine is turned on your own performance, searching for a flaw that might be the one that cost your client their freedom. Behind that closed door, the jurors are doing exactly what you'd hope and fear they do. They're arguing. They're dissecting your every word. One juror is convinced of your client's innocence. Another is certain of their guilt. They've pinned exhibits to a corkboard. They're rereading the judge's instructions on the law, words that are dense and confusing even to lawyers. They send out a note with a question. "Your Honor, can we re-examine the security footage from the gas station?" Or, "Can you please clarify the legal definition of constructive possession?" Each note is a brief, tantalizing glimpse into their thought process. When the bailiff comes to get you, you hurry back into the courtroom. You, the prosecutor, and the judge huddle together to discuss the note. Is this a good sign? A bad sign? You try to read the tea leaves. A question about a key piece of your defense evidence might mean they're taking your argument seriously. A question about the prosecutor's strongest point could spell doom. It's all speculation. It's all a gut-wrenching guessing game. And then it comes. The call. Or the bailiff walking briskly towards you with a simple message. "We have a verdict." Time seems to both stop and speed up all at once. The air is sucked out of your lungs. You find your client, place a steadying hand on their shoulder, and say the words they've been dreading and praying to hear. It's time. The walk back to the courtroom is the longest walk in the world. The gallery is filled now with family members, reporters, court staff. Everyone knows. The atmosphere is electric with a tension so thick you could cut it with a knife. You take your seat at the defense table. You instruct your client on what to do. No matter what happens, show no reaction. No outburst, no relief. Just sit there. We'll talk about it after. It's a crucial piece of advice, but it's like telling a person not to breathe. The jurors file in. They don't look at you. They don't look at the prosecutor. They look at the floor, the ceiling, the judge, anywhere but at your client. This is the moment of courtroom lore. The old saying is, if they won't look at you, you've lost. Your stomach plummets. You try to keep a poker face, but you feel the blood drain from your own. The jury foreperson, a man you'd pegged as a potential ally during jury selection, hands a folded piece of paper to the bailiff. The bailiff gives it to the judge. The judge unfolds it. The rustle of that single piece of paper is the loudest sound you've ever heard. The judge's face is impassive, a mask of judicial neutrality. He reads it to himself, then hands it to the court clerk to be read aloud. The clerk says, "Will the defendant please rise?" You and your client stand up. Your client might be shaking or they might be eerily still. You put your hand on their back, a small gesture of support that feels totally inadequate. The clerk clears her throat. On the charge of armed robbery in the first degree, we the jury find the defendant. There is a pause that stretches for an eternity. In that single second, two completely different futures branch out before you. In the first future, the clerk's voice rings out. Not guilty. A collective gasp. Then a sob erupts from your client's family in the gallery. Your client sags against you, the weight of the world lifting from their shoulders in a single shuddering exhale. Tears stream down their face, but these are not tears of sorrow. They are tears of rebirth. They grab you in a hug that threatens to crack your ribs, whispering thank you, thank you, thank you, over and over again. You've just handed someone their life back. You walk them out of the courtroom, past the glowering prosecutor, and into the hallway where their family engulfs them. You shake hands with a tearful mother who tells you that you saved her son. There is no feeling on earth like it. It is a profound, intoxicating validation of everything you've worked for. You have stared into the abyss of the state's power and you have won. But there is another future. A darker one. In this second future, the clerk's voice, cold and final, says, guilty. The word hangs in the air, a death sentence for the life your client knew. Your client's knees buckle. A wail of pure agony comes from the gallery. A sound you will never forget. Before you can even process it, you hear the sharp metallic click of handcuffs. The court officers are moving in. Efficient and impersonal. Your client is no longer your client. They are a prisoner. They look at you, their eyes wide with shock and betrayal, as they are led away. Their family is collapsing into a heap of grief. And your job has just changed. There is no time for your own disappointment. No time for the feeling of failure that is washing over you. You must immediately pivot. You turn to the sobbing family and start explaining the next steps. The sentencing hearing. The appeals process. You have to give them a sliver of hope to cling to, even when you feel hopeless yourself. You have to be the professional. You have to be the rock, even though you feel like you're crumbling on the inside. You'll go home that night and stare at the ceiling, replaying every single moment of the trial, wondering what you could have done differently. That client's face, the sound of those handcuffs will haunt you for weeks, months, maybe forever. So, do you have what it takes? It's not just about being smart or a good public speaker. Can you live on that knife's edge of human experience? Can you handle the whiplash of saving a life one month and watching another one be destroyed the next? Can you comfort a weeping family after a guilty verdict with the same conviction you celebrate with a joyful one after an acquittal? Because this is the job. It's not just arguing in court. It's managing the highest highs and the most crushing lows that human beings can experience. It's the ability to absorb that trauma, that victory, that defeat, and get up the next morning to do it all over again for someone else who has everything on the line. And doing it all over again isn't just about showing up to court with a fire in your belly. It's about understanding a side of this profession that law school barely touches, a side that determines whether you'll burn out in 6 months or build a career that lasts a lifetime. It's the business of justice. Because whether you work for the state or for yourself, criminal law is a business. And you have to decide what kind of business you want to be in. On one side, you have the public defenders, the frontline soldiers in the war for constitutional rights. If you become a public defender, you will likely never worry about where your next case is coming from, because it's already on your desk. In fact, there are probably 100 more cases stacked right behind it. Your caseload will be staggering, overwhelming, a relentless tsunami of human misery and bad decisions. You'll be underfunded, understaffed, and often underappreciated. You will spend your days in crowded, chaotic courtrooms, juggling dozens of clients at a time, making life-altering decisions in the span of a 5-minute conversation in a hallway. The pay is notoriously low compared to private practice. You won't be driving a Porsche. You'll be lucky if you have a dedicated paralegal. But what you will have is a mission. A purpose so clear and so pure it can feel like a calling. You will be the only thing standing between the full, crushing weight of the government and a person who has absolutely nothing. You are the literal embodiment of the Sixth Amendment. You will learn more about trial practice in your first year than most private attorneys learn in their first 5. You will be in the trenches every single day, seeing the system for what it is, with all its flaws and its rare, breathtaking moments of fairness. For many, being a public defender isn't a job. It's an identity. It's a commitment to the principle that justice shouldn't depend on the size of your bank account. Then there's the other path, private criminal defense. Here you are not just a lawyer. You are an entrepreneur. You are the CEO, the marketing department, the chief financial officer, and the janitor of your own small business. The first and most terrifying lesson you learn is that clients don't just magically appear. You have to find them. This is the hustle. It's building a website and learning about search engine optimization. It's networking with bail bondsmen and other attorneys. It's carefully building a reputation in the courthouse so that when someone gets arrested and asks a court clerk, "Who's the best?" your name is on the short list. It's answering your phone at 3 in the morning because a potential client's family is in a panic. You have to learn how to talk about money, a skill that feels dirty to many idealists. You have to look a desperate family in the eye and explain that your expertise, your time, your ability to save their loved one from prison comes with a price tag, a retainer fee, and then you have to collect that money. You have to manage overhead, office rent, malpractice insurance, legal research subscriptions, staff salaries. The stress isn't just about losing a case. It's about not making payroll. It's a feast or famine existence, especially at the beginning. You might go a month with no new clients, eating instant ramen and questioning every life choice you've ever made. Then you land one big case that pays the bills for the next 6 months. The pressure is immense, but so is the potential reward. You control your own destiny. You choose which cases to take. And yes, the financial ceiling is exponentially higher. But regardless of which path you choose, public or private, the overwhelming majority of your work will not happen in a courtroom in front of a jury. It will happen in a cramped office, on the phone, or in a courthouse hallway. It is the art of the deal. Over 95% of all criminal cases in the United States are resolved through plea bargaining. So, do you have what it takes to be a criminal lawyer? The better question is, are you a master negotiator? Because this isn't like buying a car. This is a negotiation where the currency is human freedom. Your client might be facing a 10-year mandatory minimum sentence for a drug charge. The evidence is ugly. The lead detective will make a compelling witness. The prosecutor knows it. You know it, but you also found a procedural error in the search warrant. It's not a slam dunk, but it's something. Crack in their case. The prosecutor, wanting to avoid the risk and the work of a trial, offers your client 5 years in prison. What do? Your client, terrified, might be desperate to take it. 5 years sounds better than 10. It's your job to be the calm in their storm. You have to objectively analyze the strength of that search warrant issue. What are the odds a judge will actually suppress the evidence? 20%? 30%? You have to know the prosecutor. Is she a hardliner, or is she reasonable? You have to know the judge. Does he have a reputation for siding with the state on motions to suppress? You go back to the prosecutor. You don't scream. You don't pound the table. You calmly and professionally lay out the weaknesses in their case. You file the motion to suppress to show them you're serious. You are leveraging risk. You are forcing them to confront the possibility, however small, that they could lose everything. Suddenly, the negotiation changes. The new offer is 3 years. Now comes the hardest part. You have to take that offer to your client. You can't make the decision for them. You can only advise. You have to explain in the clearest possible terms the choice they face. You can take this deal and you will be guaranteed to serve 3 years in prison. Or we can go to trial. If we win, you walk out a free man. If we lose, you will almost certainly be sentenced to 10 years. I believe we have a 30% chance of winning. Look into another human being's eyes and have that conversation. Watch them wrestle with a decision that will define the rest of their life, knowing your counsel is guiding them. That is the reality of criminal defense. It's a game of risk management where the stakes are measured in years, in lost moments with children, in a future that hangs precariously in the balance. It requires a profound understanding of legal strategy, human psychology, and the cold, hard math of probability. This high-stakes dance requires you to build a strange and complex relationship with your adversary. Law enforcement. You will be cross-examining a detective on the stand one day, trying to dismantle their credibility and expose the flaws in their investigation. The next day, you might be in that same detective's office, trying to negotiate a favorable surrender for a different client. You are opponents, but you are also part of the same small, interconnected courthouse ecosystem. You can't be a jerk. If you get a reputation for being dishonest or for making every case a personal war, they will shut you out. Information will dry up. Every request will be a battle. Every negotiation will start at zero. But if you build a reputation as a tough, honest, and professional advocate who keeps their word, you develop capital. Detectives might give you a heads up. Prosecutors might be more willing to listen to your side of the story. You learn to walk a fine line. fiercely advocating for your client without burning the bridges you will need to cross tomorrow for the next client. It's a professional respect born from the shared experience of working in the grimy, difficult world of crime and punishment. You have to be a warrior in the courtroom and a diplomat in the hallway. But that professional courtesy, that shared understanding, is more than just a nicety. It's a survival mechanism, because this job isn't a single trial. It's a war of attrition fought over a lifetime. The biggest enemy you'll face isn't a prosecutor, a difficult judge, or even a guilty client. The biggest enemy is the slow, creeping burnout that claims so many brilliant legal minds. It starts subtly. The cases begin to blur together. The faces of your clients, once so distinct and important, start to look the same. The righteous fire in your belly cools to a cynical ember. You start to see the justice system not as a noble pursuit of truth, but as a giant impersonal meat grinder. And your job is simply to negotiate how finely your client gets minced. This is the abyss every criminal lawyer stares into. The exhaustion isn't just physical from the long hours. It's spiritual. It's the exhaustion of carrying the weight of other people's worst moments, day after day. It's the exhaustion of fighting a system that is overwhelmingly powerful and, at times, seemingly indifferent to the humanity it processes. You will have days where you feel like you've accomplished nothing. You'll have weeks where every motion is denied, every argument is dismissed, and every client is convicted. You will sit in your car at the end of the day, the silence of the parking garage roaring in your ears, and you will ask yourself, what is the point? And in that moment you have to have an answer. You have to have something to hold on to. For some, it's a single case, a memory they can call upon to reignite that fire. Let me tell you about a case like that. It wasn't a high-profile murder trial. It was a robbery. My client was a kid, barely 19, with no prior record. The evidence was strong. An eyewitness picked him out of a lineup. His alibi was weak. The prosecutor offered a plea deal. 5 years in prison. The kid was terrified. He was looking at me, his eyes wide with a fear so pure it was almost childlike, and he was ready to take the deal. He just wanted the uncertainty to end, but he kept saying over and over, I didn't do it. I swear I didn't do it. Every instinct told me to advise him to take the plea. A trial was a massive risk. If we lost, the judge could give him 10, maybe 15 years. Protecting your client sometimes means protecting them from the catastrophic risk of a trial. But something in his voice, in the way he looked at me, I believed him. We rejected the deal. The prosecutor was furious. The judge was annoyed. My own colleagues thought I was being reckless with a young man's life. The trial was a nightmare. The eyewitness was confident, pointing a finger directly at my client. Our alibi witness crumbled under cross-examination. For 2 days, I felt the physical weight of this kid's future pressing down on my shoulders. I wasn't sleeping. I was just rereading transcripts, looking for something, anything. And then I found it. A tiny detail in the initial police report. The eyewitness described the robber's jacket as having a specific logo on the sleeve. But in every other statement, and in her testimony, she never mentioned it again. It was a thread. A tiny, insignificant thread. On the final day of trial, during my closing argument, I walked the jury back through everything. And then I focused on that jacket. I asked them, why would she mention it once with such certainty and then never again? I suggested that perhaps the police had, unintentionally or not, pointed her towards my client in the lineup. That the logo she saw was on his jacket in the photo, not on the robber at the scene. That her memory had been contaminated. I argued that the state's entire case rested on the memory of one person, in a high-stress situation, a memory that had a crack in its foundation. A small crack, but a crack nonetheless. And that crack, I told them, was the very definition of reasonable doubt. The jury was out for 6 hours. 6 hours of the purest agony you can imagine. The kid's mother was in the back of the courtroom, silently weeping. The kid was just staring at the table, pale as a ghost. When the jury came back in, I couldn't breathe. The foreman stood up, cleared his throat, and refused to look at us. That's usually a bad sign. And he said the words, on the charge of robbery in the first degree, we the jury find the defendant not guilty. The air left the room. The kid collapsed into my arms, sobbing. His mother let out a sound that was half scream, half prayer. In that moment, none of the sleepless nights, the stress, the doubt mattered. We had held the system to its highest standard. We had protected an innocent person from the machine. That feeling, that is the fuel. That is the memory you cling to when you're sitting in that silent parking garage, wondering what the point is. The point is that moment. But you must understand those moments are rare. They are islands in a vast ocean of difficult, messy, and heartbreaking realities. For every client you save, there are dozens you can't. You will represent people who have done terrible, monstrous things. And your job is to give them the same zealous defense you would give the innocent kid. Because the principle of the Sixth Amendment isn't about liking your client. It's about believing that everyone, regardless of their actions, deserves to have their rights protected. It's about ensuring the government has to prove its case every single time. You are the emergency brake on the power of the state. It's a lonely and often thankless job. The public will misunderstand you, even vilify you. They'll ask, how can you defend those people? And you have to have an answer for that too. Not just for them, but for yourself. You have to understand that your role isn't to decide guilt or innocence. That's the jury's job. Your role is to be a champion for the process, to be the guardian of doubt. This changes you. It has to. You will never see a news story about a crime the same way again. You'll immediately question the narrative, look for the holes, wonder about the police investigation, and think about the human being at the center of it all. You will develop a deep, abiding skepticism of authority. You'll also develop a profound, if complicated, empathy. You'll sit across from people who have made the worst mistakes of their lives, and you'll see not a monster but a person whose story is often filled with poverty, abuse, mental illness, or addiction. You'll learn that the line between a good person and a criminal is often much thinner and more arbitrary than society wants to believe. This is why winning in this field is so different from what you see on TV. A win is often getting a felony dropped to a misdemeanor so your client doesn't lose their professional license. A win is convincing a judge to sentence your client to a rigorous drug treatment program instead of a prison cell where their addiction would only fester. A win is negotiating a plea that gets a client home to their children in 2 years instead of 10. These are the victories that truly define the career of a criminal defense lawyer. They are quiet, unglamorous, and they change the entire trajectory of a human life. So, we come back to the original question. After this entire journey, after peeling back every layer of this demanding, draining, and deeply important profession, do you have what it takes? It's not about being the smartest person in the room. It's about having the endurance to be the last person standing. It's not just about public speaking. It's about being able to connect with a jury of 12 strangers and make them care about the fate of a person they are predisposed to dislike. It's not about having a strong stomach for crime scene photos. It's about having a strong soul that can absorb the trauma and despair of others without shattering. Can you find comfort in the gray areas of life, where morality is not a clear-cut choice but a tangled web of circumstance and desperation? Can you fight with every fiber of your being for someone you may not even like, let alone believe? Can you face down a judge, a prosecutor, and the full immense power of the government, armed with nothing but the law and your own conviction? Can you handle the losses that will inevitably come, and still get up the next morning, put on the suit, and walk into another courtroom, ready to fight all over again? Because becoming a criminal lawyer isn't a career choice. It's a choice about who you want to be. It is a promise to stand in the gap for the accused, the forgotten, and the damned. It is one of the most difficult paths anyone can walk. But for the very few who are built for it, who have that unteachable blend of cynicism and hope, of toughness and empathy, of intellect and heart, it is the only path that matters. It is the fight of a lifetime. The question is it yours?